Criminal defense attorney Ryan Pacyga, and today I want to talk to you about a case study. Criminal sexual conduct cases come in a variety of sorts, and they're called different names in different states. But in Minnesota, they're called criminal sexual conduct cases, okay? And you've probably heard of the term statutory rape before. What that is it doesn't mean necessarily that there was any force or coercion or anything for sexual contact or sexual penetration, but rather the accuser is someone who's under the age of 16, which is the age of consent in Minnesota generally, and the actor is older than that. In this case, my client was charged of being 3 years or more older than this accuser, right? And so he was charged with a first degree, which is penetration, and that carries up to 30 years in prison, but the guidelines call for generally 12 years or more in actual prison if you're convicted of that count. And he was charged with some other counts in that case as well. And this all kind of started in a situation where, he and her had kind of met on Snapchat, as a lot of, people in their younger ages do nowadays. And so they're fishing around on Snapchat, and they meet on that. And she asks him to come over, and he comes over. And one thing leads to another, and then there's sexual things that are happening between them. Well, her parents found out about it, and then they end up calling the police, and she had told him that she was 16 at the time, and turns out she had lied to him about it, and she was underage. And given the age difference there, there's a defense sometimes that applies in these situations, but not in this particular case for her lying about the age, okay? And anyway, the parents were really upset, of course, that their daughter had done sexual things, and she had told them, and then later the police, that she was forced into it and this, that, the other thing. Well, when the police went to interview him the same day, in fact, he told them, "I'll tell you everything." He was freaked out when he found out that she was underage and said that she told me that she was 16. And he went on to tell them what I think was a very honest account of everything that happened. And he ended up getting charged because of the age difference, okay? Now, the prosecutor was going after him hard, saying that he, forced her and this and that and the other thing. And I kept demanding additional evidence besides the regular packet of evidence called discovery that the state sent over. I think I was aware that she had a different Snapchat account that she wasn't telling police about, and some other details, and we kept pushing for additional evidence. And I was holding firm to our client's version of the story. Remember, he was very honest with the police right when they interviewed him, and he didn't have to. He didn't have to talk to them, but he willingly did it before he even had a lawyer, and said, "Listen, I'll tell you everything." He was just shocked that she was underage. So eventually, though, because there's not a defense in his particular case for the age difference, he was in a situation where he can't go to trial because it's illegal for him to have sexual contact or penetration with her, even if it was all consensual, because consent isn't a defense with that particular age difference, okay? And so it was a situation where he couldn't go to trial, or he'd really get hammered on a sentence there. But at the same time, it wasn't, the way I saw it, fair to be sticking him with these other allegations of the force or penetration. He was someone who had no criminal record whatsoever. And then in addition to that, he had been on an IEP, a special education plan, since middle school and high school. And in addition to that, he had some IQ testing. He had been in therapy before, and his IQ testing was lower in several fields, sometimes as low as 4 years old, all the way up to, I think, 10 to 12 on other areas. So he was 18 years old at the time of this. So he's not in the same position as some people who don't have those challenges, right? And so I kept bringing that up. Well, finally, the prosecution wouldn't agree to keep it off his record, but we got to a point where we could work out a plea where he wasn't going to go to prison, but the prosecution still had the right to seek at least 100 or up to 180 days in jail on this offense. So it was already a win on the one hand, not dealing with prison, but again, we were going to go to trial if they ever wanted that, because he was just firm that there was never any force or coercion. And I believed that, and you never want a client to plead guilty to something they didn't do, or a part of a charge that they didn't do, right? So that charge gone, by way of negotiating on it. But we weren't just going to agree to the 180 days either. I wanted to be able to argue for no jail under his particular circumstances. So we get to this plea. He enters that on a lower charge. We get to the sentencing hearing. Now the prosecutor is bringing up, even though he dismissed the charge that had nothing to do with force or coercion, the prosecutor was bringing up that he, forced her and coerced her into this, and he's so much bigger than her and these sorts of things. And I said, wait a minute, Judge. That's not what he pled guilty to, and it's really unfair to have someone plead guilty to a different charge and then act like you get to sentence them on the higher thing that he didn't plead guilty to and that wasn't proven beyond a reasonable doubt. And I'm telling the judge this in the arguments, and also telling the judge that despite some things that the client said in what's called a pre-sentence investigation on his take on the events, that because of some of his cognitive issues, we're not dealing with someone who communicates these things as well in a probation interview later. Well, there was something that caught my eye, and this is a lot of times judges have an idea of how they're going to sentence someone even before the lawyers talk. They've read a pre-sentence investigation report, they get some history on the case and about the defendant, so they go into the sentencing hearing knowing a fair amount of things. But lawyers can still be effective in those moments. And as I'm talking, the judge begins to write something, and I notice that. And this is after the prosecutor's just hammering on my client. And all of a sudden, the judge says, and this doesn't happen very often, she goes, I'm going to take a recess. And I knew at that point we had her attention. She waits 5 or 10 minutes. Obviously, she had to think some things over and look at some other things that I had brought up. And she comes back out. And not only did we avoid prison for our client, but the prosecutor seeking that 180 days and probation's recommendation that he serve the 180 days, the judge gave him 15 days with credit for 15 days, meaning when he was originally arrested on this, he sat 15 days in jail before he bonded out. She made him do no more jail at all. And we had done some good things to advocate for him there, and he had gotten proactive in some things that we were able to help him with for some therapy and things like that. That made a difference. We talked about what he should talk about with the judge that would make a difference, but I wanted him to come from here when he was doing it, so I gave him some guidelines about some things to think about, but didn't script it for him, because if you do that, it's not authentic, and a judge wants to hear, authentic reasons, not only from the lawyer, but from the defendant if they're willing and able to talk about those things. So this was a situation, his whole family was, first of all, panicked that he was going to go to prison at 18 years old. And then after that, even after the plea agreement, worried that he'd do, the 180 days that the prosecutor got to ask for. There were hugs all around after. But the most important thing is now he's going to be on probation for 5 years. He's got to do some classes and some other consequences that come from these cases. But he's more than just this case, and the judge recognized that as well. The judge recognized that as these, young people are navigating their hormones going into their adult bodies and all of these things that are happening here, that there's an opportunity for redemption, that it wasn't fair for the prosecutor to say, okay, we'll allow you to plead to a lower charge and then play got you at a sentencing hearing and go right after you for that top charge again and that conduct. And she called out the prosecution for that, and I was really happy to hear that. But there was a long journey with the client. I was representing him for probably a year and a half. Got to know him as a person, not just about the case. Got to talk with his parents and learn about the struggles that he had and some things that were happening as his family as a youth, and then the cognitive issues and the mental health issues that he had, so we could fully tell his story, not only to a prosecutor to at least get them to come off of the top count, but then to the judge and point out exactly why, in our view, a lengthy jail sentence wouldn't be warranted in this particular case. And thankfully, we had an experienced judge who saw both sides of the arguments, but also has experience in these cases, and she was able to come to a decision that I think reflected accurately both sides of the case and what was needed, what society needs, what the defendant needs, but also understanding that nobody wins in these situations, right? These are not fun cases for anybody. They're hard for a defendant. They're hard for an accuser and their family, and they're hard for a defendant's family. Anyway, so that's a good outcome. I was told to make a video about it. The family was really happy with the representation. They felt like I treated their kid like he was my own, and that's an important part of the work we do. So if you have any questions, I'm criminal defense attorney Ryan Pacyga. You can find me at arrestedmn.com or call me at 612-339-5844.